Stéphanie Yon-Courtin, thank you very much for agreeing to discuss with us the issues related to Digital Markets Act. And as we all know, you are one of those legislators who has both the experience in the substantive issues of competition law sensu stricto, but also who is directly involved in the process of designing the substantive provisions of the DMA. So you've been the rapporteur of the opinion of European Parliament Economic and Monetary Affairs Committee. We had strong discussion in the academic community about this version of the DMA. So you have this holistic understanding of the DMA, and judging on where we are currently, what is your overall impression and view? Are we on the right track with the DMA as it is now?
Well, first of all, thank you, Oles, for this time, a very precious time of exchange. I think we are moving forward, and we will strike a deal, hopefully by the beginning of April, as foreseen. But I have high hopes on that. In this sense, I think the progress goes as expected, and everyone is committed to get an agreement as soon as possible on this crucial regulation. We knew from the beginning that Parliament had a lot more requests than the European Council regarding the DMA, so we have to deal with that. But the Commission is playing the honest broker, I think, to make sure we achieve an ambitious regulation that will not be unnecessarily challenged. Overall, I'd say that I am satisfied by the state of play and path of negotiation. The main issue that worries me, to be honest, is the governance. The text is supposed to enter into force by the end of the year, and it will be a massive workload with closing of antitrust procedures, designation decisions, core platform services decisions, and so on at the same time. So yet we still have no idea how the Commission will organize itself to enforce this regulation. So the questions are, who will be responsible within the Commission? Because the Commission is the sole enforcer, but who within the Commission? Will we only have to rely on 80 extra people, or maybe less? That's what we are hearing. Will those people have some specific skill? Because we are talking about quantity of people, but what about the quality? Because, I mean, specific skills are required, you know, such as behavioral economists, data scientists, and so on. Or will there be civil servants moving from one director general to another? All these questions are paramount of importance if we want to be taken seriously, but I do not have an answer yet. And to be honest, this is one of my main concerns. This is the second leg, let's say, of the legislation, enforcement.
Indeed, and obviously it is hard to address these concerns in the text of the DMA itself, because the Commission adopts its decision in college, so it's for the Commission essentially to decide who precisely. But it could be actually a conflict of narratives essentially, because different DGs have different strategic priorities, different understanding of things. So indeed, it's one of the substantial issues, one of the most important paradigmatic things. And if you can, look at obviously you are aware of the latest development, and you are familiar with the all text, all versions of European Parliament, the Council. Is there any specific provision in the DMA which concerns you in particular?
Yeah, in the ECON Commission, you know, Economic and Monetary Affairs of the Commission, where I'm Vice President and for which I am Rapporteur, I highlighted 5 specific points. The first is the role of data, and today the Data Act will be announced, and I mean it's clearly a key issue. You know, the gatekeepers privilege access to data, give them a comparative advantage, definitely that prevents any competition. And it's definitely time to treat data as a true asset. That was the objective of several obligations that aim at limiting the massive and endless power of gatekeepers in that regard. So this is my first, let's say, priority or specific provision, which I think is key. The other one is governance. I've just talked to you regarding that, but regulating 10 to 15 companies like the size of Google, Facebook, or let's say Meta or Amazon will require, as I said, expertise, resources and experience commensurate with their own means. And I think in addition to know who will be in charge within the European Commission, there is also a need for a clear articulation with national regulators. And here, I think national competition authorities have a clear role, a leading role. They have each developed their digital expertise to support the European Commission's enforcement, within this European competition network. And some of them, like the German, the Dutch, and the French have already very key expertise in that respect. They've already set up a very strong task force dedicated to digital issues when it comes to competition. So I think we need them as co-leading this regulation, in which, of course, the Commission has to be the sole enforcer at the end. As for now, we all agree that the Commission should rely on national authorities' support, but we are also gathering, and it's important because the DMA is not only about competition, we're gathering all competent authorities together within, this high-level expert group. And however, I think we still have to discuss the role of the European Competition Network. I know that the Council pushed for that, and I was very in favor of that. It wasn't the case of the majority of my colleagues at the Parliament. So, but I have high hopes that this will be concluded positively within the trilogues, and I'm definitely in favor of this reference, as I said, like the Council, because the existing and well-functioning network will be definitely useful to deal with the DMA, to help to support the workload of the Commission. And this DMA, as I said, is very at the crossroad of internal market and competition law. So this is particularly true if you think of dealing with Article 12, and information on acquisitions, but also on the interplay, between antitrust cases and DMA procedures. So this is my second point. The third is killer acquisition. And this was a big, I think, loophole of the DMA, which remains an internal market tool and not a competition law tool. However, in ECON, we extended the information obligation for all intended concentration, and we also introduced the reversal of the burden of proof. And the competitive market is not a market where 5 companies alone buy more than 1,000 startups. So far, we had to give up on the reversal of burden of proof, which is more related to competition law. So we feared there would be a case, a concern on the legal basis. But the request from ECON to extend the obligation of information to all acquisition related to data has been accepted, which is a success. And the aim was to ensure that potential acquisition from gatekeepers, like in the health sector, in the insurance sector, and the banking sector, could also fall into the scope. So this is a great success, as I would say. The other point is the deterrent fines. The prospect of a 10% cap has never been applied. And it does not frighten anyone. We suggested a threshold of at least 4 of global turnover for serious violation of the DMA. That's quite a far-reaching addition that comes from our ECON committee. The point was to underline that even if the Commission can fine up to 10%, it has never happened, really. I mean, I think, well, for Google, I think the biggest fine was around 4.5%, but discussions were ongoing on a higher cap, up to 20% or 30%. But that will not change a thing, I do think, because it might only give an opportunity for gatekeepers to challenge, the proportionality of this regulation. So that's why I suggested to have a threshold as a political signal to the Commission to incentivize it to give different fines. And fines, are not just the cost of business for gatekeepers. The amount of fines are enormous, of course, given their huge turnover. But for a reminder, Apple is the first company in the world to exceed 3,000 billion of capitalization. And we suggest this threshold not for minor breaches of the regulation, of course, but for major ones, such as systematic non-compliance. I have no doubt that gatekeepers will be able to afford several fines, even that could hurt somehow their reputation. And we need like a teeth regulation, and for that we need big fines. And gatekeepers need to understand that if they don't respect their basis of obligation and interdictions, such as Article 5 and 6, there will be massive consequences and automatic ones. However, we still have, and we had some discussion on the proportionality of this proposal, and the fact that it has to be adapted to the individual situation. And the aim is not to prevent the Commission to fine companies anymore, because it will fear the Court of Justice decision. So we know that gatekeepers always challenge fine decisions. So I'm suggesting now, right at the moment, so it's a timely discussion we have, to work on the methodology for the calculation of fines, based on new guidelines to be developed by the Commission. And the idea would definitely to have different guidance between the DMA and antitrust, and it will make sure that the Commission will be able to deliver high fines if needed, and so I think it's important to have a clear notice on that. So we should make sure the most of the DMA not being a competition law, so that's important. And last but not least, compliance officers. Because I think it's important, and the idea was to designate compliance officers similar to trustees under the European merger regulation. Independent compliance officers appointed by the Commission must be present within the gatekeepers' premises to assess on a real time their compliance with their obligation and access the information needed. Compliance, must not be a one-shot. We can't say, okay, well, we've had a look once, that's fine. No, we have to make sure we follow this up quite closely. And so far, it seems that this idea will be taken on board, except from the fact that they will be appointed by the gatekeepers with the necessary safeguards of being independent, which is what I fear, but this was the decision by so far, and so I would have preferred to have them appointed by the Commission, or at least approved by the Commission, but it's still a good improvement.
Indeed. So you have articulated 5 aspects, and let us start just very follow-on questions with on each of these 5, if I may, in reverse order, with compliance officers. In the version adopted by the Parliament, we see this mechanism introduced, as you said, striking the delicate balance between, on one hand, being compliance officer as a senior member of the gatekeeper management, so that she or he would act in the interests of gatekeepers, but somehow through the prism of the DMA potential objectives and liability, which is somehow an attempt to mitigate the ideal version, which you just have mentioned, would be somebody either appointed or approved by the enforcer, whoever it is. So basically, you think this is kind of a happy medium. This was probably a nice compromise indeed. And so then you mentioned fines. And here, obviously, we hear discussions about 4%. When we talk about a huge turnover, it could somehow deter the enforcer from applying the case, because it would be close to scandalous to apply billions fine in issues of non-compliance, even if you talk about systematic non-compliance. And obviously, we hear these discussions, and I understand that you develop it further by suggesting that we need a guidance where we will do all the kind of calculus and prescript and suggestions, recommendations on how should we apply it, in what context. But also we see the cases of, for example, we have a gatekeeper, potential gatekeeper, which is happy with paying fines, in the Netherlands, I'm talking, for example, which is happy to pay periodic fines, but still not change the conduct. Do you think there is a potential room for the DMA to be, you know, a severe stick in this respect?
Well, I think fines are not enough in themselves. So anyway, I mean, I would say it's a good signal, and it's much more a signal for the reputation of the, I think, of the GAFAM, rather than you know, it's pocket money, to be honest, for the gatekeepers, given their capitalization, or so. I mean, but I think it's a clear signal, and it won't be enough. And we've seen that, you know, in the past antitrust cases. So what we need to do in addition to that, because DMA needs to go hand in hand with antitrust law, and also as far as remedies are concerned, we need to have flexible and really targeted remedies, and that's where, in addition, remedies are very important. Behavioral and structural remedies, of course. I think this does matter. I think we need to have a broad picture of the remedies, of the sanction, and we can't take only one, let's say fines, for example, as just one pure element of deterrence. Well, I must say that I have never pushed for that, because I know it won't be possible, because we don't have a European criminal law. But disqualification orders in some jurisdiction is quite appealing, and I think it's quite interesting. I don't think it has been that much applied and used in these jurisdictions where it is enforced. But I think this is something which would be interesting to make you know, the head of the companies concerned, you know, being conscious about what they are doing, and to make them personally kind of responsible for what they are doing. Well, this is probably one step we will have to discuss, but I mean, well, I'm just telling this to you, but just one thing I have for a long time, basically.
Indeed, and we have some jurisdictions which have left the EU recently, which have quite effective mechanism of direct disqualification. So moving back then to question 2.3, mergers. I wonder what's your opinion about a recent paper produced by a few academics, including Giorgio Monti and Alexandre Destrel, suggesting, among other things, that even though the merger regulation was adopted as a competition tool and thus requiring unanimity, it's still possible, or conceptually not impossible, to introduce amendment to this legislation as one of the options by using the DMA, using a harmonization tool. Is it a little bit too proactive, or it's still feasible in principle?
Well, I wish it could be feasible. I think it's legally not feasible. We asked, to be honest, our legal services from the Parliament, Council, and Commission, and we came to the conclusion that I think it would be easily challenged by the gatekeepers themselves, because I mean, again, I mean, the legal basis is not competition, and here the legal basis is the internal market. So that's why we pushed a lot, and that's why I'm saying that I was very happy to make sure that we can broaden the you know, the obligation of information to all sectors when we manage to include data, you know, concentration on data, because basically data is everywhere now. And this was my concern. All the most important that, I mean, there's no real willing from the European Commission to amend, I mean, the European merger control regulation, the ECMR, from 2004. So and it's one regret I have, that I wish we could have been we could have gone further, even with the reversal of the burden of proof, asking and requiring the gatekeepers to show that there was no major impact of their contemplated acquisition to the market. But I mean, this would have been, I think, a real hurdle in the fact that maybe it could have been very risky, from the start, to take this, as I said, risk, to have a lot of challenges before the court. And I think it would give a wrong signal on the fact that finally this regulation does not work. And this comes to my first main concern, which is enforcement and enforceability of this instrument. And
indeed, and basically maybe a follow-up question: do you think it's still feasible to anticipate that the regulation will be challenged in court, even regardless of this? It's quite a plausible opportunity.
On general, I have some echoes. If I take my previous lawyer's hat, I know that there is an ongoing legal market, which is developing a lot in law firms, which is legal challenge. And legal challenges before the court on the DMA. And of course, there are many points which will be a challenge, of course. I mean, it's somehow it's very an historic text and regulation, and I'm sure there are still some doubts and some application and some many ways of interpretation of the text. So that's why finally we decided not to push, for these risky provisions, which at the end would be detrimental for all the text, So that's why we needed to choose. And I think really, as you said, I mean, it's a happy medium. Having this overall obligation to inform on all sectors, any contemplated acquisition is just good so far. I mean, if we have the opportunity, I'm not saying that we won't adapt and we won't add this finally at the end, but so far, let's target and let's focus on the spirit of the regulation, and we need some swift application and very auto direct applicable obligations and interdictions. So we have to be quite quick. We need to be quite quick.
Okay, so from number 3 to number 2, namely governance, or the division of powers or competences between the Commission, whoever it might be, which DG, and member states. Again, member states qua ministers or national competition authorities or national regulatory powers. This is again a question in itself, but still, just speaking broadly, obviously we understand that one of the advantages of this kind of asymmetric tool, and one of the significant bargaining chip in the regulatory dialogue, is having the unanimity, or how to say, exclusive enforcement in the hands of the European Commission, because this could somehow overcome the potential of what we could call leniency backfire, where you somehow discourage whistleblowers from announcing their participation in some conspiracy by having private enforcement as a backdoor, essentially. So you receive immunity from public enforcement, but you get not immunity from private enforcement. I wonder if this parallel would be plausible here, when basically the Commission, in this kind of very delicate game of interpreting the obligations of Article 6, for example, or selecting priorities, having this kind of internal dialogues or multi-logs with different gatekeepers on various occasions, trying to make them to comply not only with the letter, but with the spirit of the DMA. One of the bargaining chips could be somehow, okay, you stop seriously with practice A, and we somehow promise to turn a blind eye to practice B and C. And then when the national enforcers could apply this practice B and C, wouldn't it undermine it? Is it too esoteric scenario, or it's something which is possible in principle?
I don't think it's possible, but it could be a scenario. But I think at the end, the sole enforcer is the Commission, and this is, I think, the main difference between antitrust. When it comes to the European competition network, when I mean, there is definitely allocation of work within one case, and the Commission at the end of the day might not be the ultimate enforcer, because it can, be allocated to other different competition authorities, can be or the Commission at the end. But then the DMA has been on purpose made to have only one single enforcer. So I don't think there will be a bargaining. There could be this kind of bargaining. There will be a dialogue, but not on all the obligations and provision. And this is the difference between Article 5 and 6, which we are still discussing now, because as you may know, the European Parliament has changed a lot and has extended a lot Article 5 and 6, and has moved many provisions from Article 6 to 5 to make sure they are self-executable, and they are exempted somehow from the dialogue, because I mean, dialogue is a good thing, but when it comes to gatekeepers, I mean, it's a great tool to save time, and at the end of the day to stay on the market and have the competitors exiting it. So out of it. So I think I don't think they will be risky. I know that some of national competition authorities, Germany, for example, they want to have their say. And if there is a parallel procedure, which could be the case, because, for example, the Bundeskartellamt in Germany has already started to investigate, then it can be difficult. But again, the DMA is not, the alpha and omega, when we say in French. It's not the only regulation. We also have 102, and we also have antitrust, and we can deal with these two tools to make sure that at the end of the day, we have the more efficient response to the market. So I don't think this will be, I don't think, well, there will be a question of allocation of cases between the Commission and the national competition authorities at the end of the day. And this is why when we discuss about the need to adopt the format of the European competition network, I would say that we need to adopt this format in a softer manner, much more softer and lighter, I would say, than antitrust matters, because then we definitely need to have in mind that that's for the European Commission to decide at the end of the day, final resort, last resort, even if so she will be the pilot on the plane, even if the co-pilot needs to be, to my view, the national competition authorities, with the help of the stewards, who are the all the regulators, national regulators, privacy, in charge of privacy, in charge of sector regulation, telecoms, for example. So this will have to be dealt within, the highest expert group.
Okay, so then the question, moving it to the first one, which you mentioned, the data is everything, and this is obviously the case. You basically said, among other things, that current gatekeepers, or do I understand correctly this observation, that current gatekeepers have benefited significantly from the previous regulatory period where we didn't have sufficient understanding, or maybe we were too illusioned with this kind of vision of internet bringing freedom and access to information to everybody, that we were trying to somehow to non-enforce any kind of real life norms. So they benefited a lot from this Wild West Wonderland situation by accumulating so much data, by training their algorithms to this kind of endless point where they come in. So summing up my question, and obviously having the gatekeeper's position by definition implies that they have an access to pretty much everything they need to have an access to. Against this background, we have this legitimate and very reasonable discussions about the enhanced privacy protection and protection of data. We look at the DSA, how significantly we promote this vision. I wonder if this couldn't backfire somehow on the potential newcomers, or obviously there is no way to solve this dilemma, but should we at least acknowledge the dilemmatic nature of the situation where those who benefited a lot don't need to use tricky techniques, essentially gray area techniques anymore, to target and to access all this information about end users, because they know this, and business users, because they know all this information anyway. And by being significant, by increasing our vigilance towards privacy protection, we unintentionally cement the status quo.
You're right, and this is you're right, and this is one specific provision discussed within the trilogue that I would definitely not want to see, in the final text. I really would like to avoid having clear gateways for gatekeepers to kind of circumvent their obligations. Gatekeepers, to justify their behavior, already often use, as you said, the safeguards to some obligations, referring to the need to ensure safety, integrity of software or privacy. And it will still exist because the rights of defense are enshrined in the treaty. So I don't see the need to underline it so clearly in the regulation. And that's why we need to make sure that we have some clear-cut regulations. And that it's important that when there's no necessity to dialogue, then we don't dialogue. I mean, then there is a provision, and it's kind of clear-cut and clear, because otherwise, of course, as you say, those who benefit for a long time of this expertise will exercise it. So that's true. I mean, this is something I really want to avoid within the DMA at the end.
Okay, so let us move now to a few questions on the procedural, if I may. The Parliament version of the discussing the goal or outlining the goals of the DMA adds to in addition to fairness and contestability goals. We also have enhancing consumer welfare and fostering innovation. Is it what do you have anything specific to add, or it's too delicate at the moment to discuss these things? Is it necessary? Would it help make it stronger, the DMA, or maybe it would make it kind of as quasi burden of proof for the Commission to show that each specific obligation or non-compliance with each specific obligation harms consumer welfare and challenges innovations? And overall, should we care that much about innovation, technical innovations, for their own sakes, without looking what are the benefits to the European Union in these specific innovations?
We have in this proposal of the European Commission, there was a mix of different objectives. And of course, since it's not only competition, it's not only consumer welfare, even if it's more B2B regulation at the end, with a clear impact on B2C. And so the discussion about consumer welfare, about this goal, consumer welfare and fostering innovation, has been long discussed. This was indeed a proposal of the European Parliament, requested by the S&D group. In the ECON negotiation, I had warned about the risk of including this objective in the regulation. In my negotiating team, some MEPs wanted to add the plurality of media, for example, as an objective. And you know, media plurality and promotion of cultural diversity are not stricto sensu objectives promoted or pursued by the DMA, which aims to primarily, I would say, tackle unfair behavior or behavior undermining the contestability of market in the digital sector. And I think inclusion of a non-related aim in the regulation could lead to unintended, we were talking about that, unintended interpretation of different obligations laid down in the DMA. The more objectives you introduce, the more at the end you have to apply to when it comes to interdiction and obligation. And so, of course, I mean, the DMA at the end would pursue wider societal aims, whether other tools seems more appropriate. I think about the DSA, for example. And you are right, pointing out the kind of loopholes it could have created with such broad concept that could have been, that could have been used maybe by the gatekeepers to justify their unfair behavior by claiming it's for the consumer welfare, you're right. We actually might have the same issue with the safeguards on data privacy and security that gatekeepers will try to use to circumvent the regulation. So we have agreed that this regulation is to contribute to the proper functioning of the internal market by laying down harmonized rules ensuring contestable and fair market. I think these two objectives are what matters. And by doing so, the consequence would be that it will benefit to businesses and consumers. As I said, it's primarily a B2B regulation. How can we manage to make these markets more contestable, and we manage to have more competitors entering this market, and also consumers? It's a B2C because at the end of the day, it will help consumers to have more choice with a lower price. So we know that the gatekeepers are already preparing all the challenges on that as well. They can on this regulation, and I'm happy that we did not give them somehow another occasion to do so more easily. And it's the same with all these objectives. The more objective you have, the more risk you take at the end, and the more challenges, legal challenges you offer to gatekeepers.
Indeed, and also this attempt to somehow distance procedural elements of the DMA from the current kind of rich legacy of ex post competition law, full of casuistics and juristic toolkits, which the most skillful representatives of antitrust profession are capable, and on legal and economic side, are capable to invoke in courts, which is essentially by using the terminology of consumer welfare, we essentially open this potentially Pandora box. Stephanie, I know that you're already looking at your watch. I assume you have only a few minutes left. Is it correct?
Yeah, it is correct. But it's great. It's a very interesting discussion we have now.
Okay, if I may ask you, then if this is the case, let us now finish up with kind of broader conceptual issues, because we have discussed a few nuances of the DMA as such, and obviously discussed the goals. But strategically, when we talk about contestability of the DMA and European digital markets, what should be the ultimate purpose, and is it achievable? Should we only look at how the gatekeepers behave on their entrenched core platform services, or should we also somehow look at trying to open these markets horizontally? And if we try to open them horizontally, then the question, the obvious kind of elephant in the room is for whom? For the second tier potential gatekeepers from the United States, or maybe from other jurisdictions, or maybe from Europe. I obviously understand that we should be neutral, etc. But is it something which somehow stimulates or influences the European Parliament? Do you sense these discussions being relevant?
I think, well, first, as you know, somehow the DMA and the DSA are for me the first two steps. And as I said, I mean, the DMA in itself will not solve all the problems, but it's just the first step. And And I think it was interesting to hear the President Macron, which reminded us during his speech on the 19th of January before the European Parliament that the regulation of the digital platform is a priority. So I think digital is a priority, like his twin transition regarding environmental. DSA and DMA has to be historic text, and our priority will be the economic regulation and accountability of digital platform. The idea behind that, and you reminded us that we need to build a true single market that will allow European champions. And now we have the word on that. And as I said, these two texts will be a first step. The DMA and the DSA are regulations that are part of a more global cake, a more global strategy. The upcoming today's Data Act, the artificial intelligence, but also the achievement of the autonomic strategy. Also, the union of capital market altogether have to go hand in hand. I mean, it's a matter of stopping working on silos. It's a first step to ensure a level playing field to compete on the basis of merit and not on unfair practices. I'm also a rapporteur on foreign subsidies instrument. And it's the same. I mean, you know, the idea behind that is that the European Union will be the first jurisdiction to have such a regulation. We can serve as an example, but we will not have the right to make mistakes when we will already know, you know, all the challenges made by the gatekeepers. It's historic, but it's not enough. And I think we still have a long way to go to allow the scale up of our startups by ensuring a real capital markets union and also using the lever of public procurement. We have many other things to do on that, and I think, as I said, the European Union is taking also the first step to achieve our industrial objective, and the DMA, and as I said, the foreign subsidies regulation will help ensure fair and discriminatory competition conditions within our market. But the European Union can no longer be satisfied with regulating the market, and we must adopt an active policy. I would say this is somehow, it's not that active, the DMA and DSA. It's just a response that was needed for a long time. Now we have to be more proactive and more active to support the industry through structuring investment, through regulatory flexibility, and an assertive choice of a preference for a European solution. And I think we need to act as our commercial partners in making sure that we favor our European champions somehow. I mean, it's something normal, reciprocity, and of stop being naive is just normal way, normal business. Because I think Europe must have a clear strategy also of public and private sector for key sectors and technologies. Like the CHIPS Act, we need to invest massively on high value added sectors where European leaderships remains possible. And we have plenty of opportunities because we have talented people, experienced people, and the European Union is also a big market for the other regions. So the rules of public procurement, I think, should reflect the challenge of technological autonomy. And public procurement has a role to play. So I think now Europe is a kind of a modern day influencer somehow. And that's why we have to make sure that, again, that's what I was telling you at the start, but it's very crucial. We need to make sure that this regulation is concretely enforceable. And we are doing this today on digital issues, but also this will be done in environmental, in social, international trade issues, and that's why these first steps have to be conclusive.
And indeed, one of the objectives of this conversation could be essentially to establish this dialogue between the competition law and economics profession, which until recently was treated any mentioning of industrial or national champions or industrial policy as a kind of the main taboo, as something which is completely which undermines and blurs the clarity of neoclassical economics, which knows the answers to all questions in all situations with scientific precision and accuracy. And now we enter in a completely new modality, and still we are somehow this. We have inherited the previous pedigree, and now it's time to create this new links and to try to establish this dialogue between the members of the profession and those who lead the area in a new way. Stéphanie Yon-Courtin, thank you very much indeed for this conversation. I really appreciate your really bright ideas and strategic vision.
Thank you very much, Oles.